Hi friends, welcome back to my channel Shruti Desai's lecture on law. We have completed with mediation and now we are going to start with RERA. Now before going to the subject, I request all of you to, if you like this channel, do subscribe for it and click for the on the bell icon. And if you want to know more about me, please visit my website www.shrutidesai.in/. Friends, now the question arises in anyone's mind why government came out with RERA, the Real Estate Regulation and Development Act 2016. In Maharashtra, there is still an act which is in force for protection of flat buyers is Maharashtra Ownership Flats Act 1963. To my knowledge, there is no other act in any of the state for the protection of the flat purchasers. For them, the only remedy was to go to consumer forum or file a suit under say Contract Act, Transfer of Property Act, or a specific relief act. These were the acts or the laws which were protecting their rights. Once again, I say that why we require a separate act, a specific act. We have seen now in so many years, property is becoming sort of an investment rather than a requirement. It is sometimes also treated as stock in trade in your books of accounts. So more and more people started buying the property, and builders were taking money. They were mortgaging the flats without the knowledge of the flat buyer, because there was no centralization or the information available to the registrar at the time of registering the flat. Even banks, there was no centralization index available that this particular flat is already sold or not. So this created, by the time a person comes to know that his or her flat is sold to another 3 people, it's too late. And maybe that person has taken bank loan and started paying the EMIs also, and yet there is no possession. This created lot of problems within the society, because it affects the family setup, it affects the financial setup, it affects the trust on the government, it affects the trust on the various institutional, and it also affects the trade and the builders. There are builders, in the High Court of Bombay we have seen so many cases under MOFA where one flat is sold to so many multiple people. There was no other remedy except to go under MOFA or go under Consumer Forum, Consumer Protection Act. That is why the real estate regulation was necessary. And see, even we go as a lawyer, sometimes we have to issue certificate of title. At that time, we take search of the sub-registrar of assurances and various other index searches. So most of the time, we get the answer that this index is torn, this record is torn, this is not available. So it is also, once again, we issue certificate of title subject to the availability of data with the sub-registrar of assurances. This is a very good system introduced by the government for the protection of the flat buyers, and it has come into force from 1st of May 2016, and it was passed by the Parliament on 10th of March 2016. There needs to be a universal protection for all the flat buyers. In Maharashtra, still the MOFA is in force, and it is for the projects which are having 8 units, and a project is of 500 square meter. 500 square meter. Any projects beyond 500 square meter and having more than 8 units are covered under RERA. Now we will see the various features of RERA. RERA is a different kind of law where all the builders across India are available on the internet under one roof, and they have to register their project with the RERA authority. In Maharashtra, it is MahaRERA. So every state has their own websites under which the builders have to register their ongoing projects. Let us see the various features of the RERA. What are the key features? No promoter can advertise, market or book a flat without registering their particular project, ongoing project with the RERA authority, and if he does not disclose the true and correct facts and the status or suppresses, it has serious consequences, which we will see when we go through the RERA entirely, one by one, section by section. The another main feature of the act is it applies to ongoing projects. Suppose on 1st of May, the ongoing projects have not received completion or occupation certificate, they need to register under RERA. So suppose there are 10 buildings in a project, 2 buildings are already over, and occupation or the completion certificate for these 2 buildings have already been obtained, and another 8 buildings are still yet to construct or complete. Then these 8 buildings, whatever details are there, the builder has to register the details with the RERA authority. He suppose on the date of implementation or enforcement of RERA, if he has received certain amount, he has to inform how many flats are sold, how many litigation is there, whether there is any litigation or not. Everything he has to mention in his website, designed in the RERA website. Exceptions, I said, 500 meters plot of land and 8 units, it is not covered under RERA, and the flat buyers in such cases, they have a remedy under MOFA, Maharashtra Ownership Flats Act. This I am talking about Maharashtra. For other states, it may be Consumer Forum or any other law like Transfer of Property Act, Contract Act, Specific Relief Act, or Transfer of Property Act. So when I say MOFA, it is applicable only to Maharashtra and no other states. When another exception where RERA is not applicable is where the promoter has received the completion certificate on the date of commencement of the act. So on 1st of May 2016, if a promoter has received completion certificate, he need not register the same project for which he has received the completion with the RERA. Now the work is of renovation or repair or redevelopment which does not fall under the provisions of RERA, or it is not for sale in the market, or it doesn't mean to be advertisement or sale of any flat, plot or building or a bungalow or villa, or as the case may be. As I said, every phase is to be treated as independent project, and suppose, as I said, 10 buildings are there and 1 building is completed, so 1 building is out because he has received completion certificate. Another 9 which is pending, payment is received on the date of enforcement of the act, it needs to be registered, and after this is I'm talking about on the date of enforcement. But now, as on today, if any builder starts with a new project, he has to first register his project with RERA. Without that, he cannot advertise his project, nor he can receive payment from the flat purchaser, that is public. So one thing is very clear, that RERA applies to the projects which are of more than 8 units and of an area of 500 and more square meters, and there is money collected from the public. Otherwise, there is no provision, according to me, in RERA for registration. Registration comes only when you collect money from the public and offer the sale. Any personal construction, suppose it is my own family property and I'm redeveloping it without collecting money from the public, neither there is a sale, and I am going to reconstruct and reaccommodate entire family. Suppose in a family there were 5 people. Now after there is an expansion of the family, so I need more space. In such case, I don't take money from the outsider, neither there is a sale. It is only for my purpose. In that case, there is no registration required with RERA. We'll stop here. Tomorrow we will discuss various sections of the Act. We will also discuss various orders, judgments of the RERA authority, appellate authority, and the High Court. Till then, goodbye. Stay tuned.